Okay, this is a Construction Board of Appeals meeting, and we're going to call this to order. We'll start out by doing the Pledge of Allegiance. Please stand. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, I guess we call the meeting to order and do the roll call.
Mr. Cook?
Present.
Mr. Palachi, is he still experiencing difficulties?
Yes.
Okay, he's trying to get online, but he will put down the time that he starts. Mr. Wizinsky
Here.
and Mr. Walter,
Here.
3-1 right now.
So I'm going to ask for any agenda additions or deletions.
I would ask that the chairman strike the approval of minutes as we do not have those on hand.
Okay, I ask that we strike the approval of the minutes from last meeting because we don't have those on hand.
Motion to approve the agenda.
Okay, I make a motion to approve the agenda for today
As amended.
as amended.
Oh, is he? So I just found out Mr. Palachi is in. He's just getting.
Yes, I am.
Okay, so the vote is 4-0 to approve the agenda as amended. And can I ask, Mr. Kaplinsky, you made the motion?
I make a motion.
Well, you did, right?
There was no vote taken yet.
Oh,
No,
and who seconded?
nobody, but I'll second.
Okay. So you can ask for a vote.
Okay, can we have a vote now to approve or for approval of the minutes that
What do
we
you-
just dropped?
The agenda.
For the agenda.
So a show of hands.
Show of hands.
Mr. Palachi, we're approving the agenda as amended?
You hear me now?
Yes.
I have no idea what that is.
So we're approving the agenda as amended? Mr. Palachi?
Yeah.
Okay, so that's 4-0 to approve the amended agenda.
Okay. So now our action item,
No, public comment.
pardon?
You need to have public comment first, Mr. Bliss.
Oh. Do we have any public comments?
And the phone number to call in is it?
Yes, I'd like to make a public comment.
We have to announce the phone number to call in for those watching live on YouTube. And that number is 231-256-8109.
And by board rules, public comment is limited to 5 minutes.
Okay. Okay, I'd like to, first of all, know if you guys actually got my appeal. I have sent you 54 exhibits as well as this. This is from, all these are my exhibits. This is Mr. This is Mr. Hunter's appeal. Did you get my appeal?
Okay, this is public comment here. We're not.
Yes, I would like to make a public comment. Okay,
I'm just
can I
clarifying,
share?
not respond to questions.
Can
in
I
public
share?
comment.
Am I allowed to share? Can you turn on my share screen?
You'll have to do that. No.
It
This is public
says
comment.
host disabled participant screen sharing. Is this an open meeting or is it not? I have a right to present things as if I was there. You are not
You
allowing
will
me
hear your
to
portion.
share.
This is public comment, sir. This is just public comment.
Yes, I know, but if I was there, I could bring an exhibit and share it with you. So since I'm not there, I can share it with you if you allow me to share it. All you have to do is undisable the.
We'll get this opportunity during the hearing. This is public comment.
This is public comment.
This is only public comment.
Okay, my concern is you've changed the order of the agenda. The public comment comes at the end. So you're going to make your decision and then people can't comment.
You have two public-
Excuse me, you'll have a chance to, later on in the meeting, to present your comments or your.
Will you allow me to share a screen of the documents? If I was there in person and you had my documents, all I would have to say is, here's document 19. Do you have my exhibits?
Yes, Mr. Chairman, may I make a comment?
Go ahead, Mr. Wizinsky.
Excuse me.
All right.
We're gonna move on. If you can do public comments, we're not sharing screens right now. You have a chance to do that later.
Okay, that's all I want to know. But I would like to know, did you get my actual appeal? Did you get my appeal with the 54 exhibit?
We have a packet that has
Can you hand that to me?
all, we have a packet with all the information from you.
Okay, that's all I wanted to know.
Mr. Wizinsky, this is your exhibit packet, as you can see. It
Okay,
is
I just
the
wanted to
complete-
make sure you had. That's all I was looking for.
We also
Thank you.
have this is also your introduction to the exhibits. Everyone received this well in advance of the session. It was hand-delivered.
Okay,
Once again,
that's
it's
all I wanted to know.
I'm running over. This is strictly public comment. This is not a debate to go back and forth.
Correct. Do you have any more public comments?
Could you repeat that phone number again,
The
Laura?
number to call in, if you are watching on YouTube, to comment publicly on this meeting is 231.
Are you on?
256-8109.
Okay, Mr. Chairman, the phone's not ringing, so I suggest we move forward.
Okay, so we're gonna move on. This action item is an appeal by William Wizinsky for a certificate of occupancy for a structure located at 12063 North Foxview Drive, Northport. This time I'm gonna turn it over to Matt, the meeting, for his ruling of the Building Safety and Code Enforcement Department.
Thank you, Mr. Chairman. Good morning, board members and everybody else in attendance. My purpose here is to give a bit of an overview of why we are here today. The building official, of course, has provided a rundown of the decision that's under appeal this morning and the technical code-related matters, and I'm happy to defer to him to comment more on the decision itself. But, you also have my memo in the packet that was presented for you today, and rather than completely repeat it, I think I just hit on a few highlights, and if you have any questions, I'd be happy to answer them. But as you know, this matter is related to a certificate of occupancy decision that was made in July of 2018 regarding Mr. Wizinsky's structure to issue a limited certificate of occupancy that would not allow use of the structure as a dwelling. At the time, that decision was based on factors including the fact that Leelanau Township denied land use approval for the structure as a dwelling, and because the Benzie Leelanau District Health Department had determined it wasn't suitable as a dwelling because it lacked any sort of water or sanitary facilities, including a toilet. Mr. Wizinsky did.
Excuse me, I just want to let you know I'm getting phone calls. I'm getting phone calls that you're not letting people into the meeting.
That is correct.
I am telling you, you are not letting people into the
That is
meeting.
correct. This is a public.
You are
meeting.
not
can watch
letting
it on
people, I'm
YouTube.
getting phone calls.
The meeting.
No, you have to have them allowed to come into the meeting in Zoom.
No, the meeting is being.
So this is not an open
The
meeting.
meeting is being brought.
This is not an open meeting.
Mr. Wizinsky, please.
Mr. Wizinsky, this is Matt's time to talk. If you want to say something, you have to raise your hand or we'll have to turn your sound off for the time being.
Okay, I'm just saying is people are trying to get into the meeting. You advertised it as you can get into the meeting or on the other one, but you're not allowing people to come into the meeting. Therefore,
is
they
correct.
can't really speak, can they?
That is correct. This is a public meeting. It's not a meeting for the public. Only members of the appeal board can be in the Zoom meeting and selected individuals. The public is not allowed to participate in the Zoom meeting. They can watch it live on YouTube. We're fully in compliance with the Open Meetings Act.
Yes, and I would point out, and not only the Open Meetings Act, but this is specifically the type of procedure authorized under the governor's executive order for electronic meetings during this period in time. It does not require Zoom at all, let alone that everybody be in Zoom. This type of hybrid approach that's being used has been used by a good number of communities where the key participants in the meeting are participating by Zoom, but the meeting is being currently live streamed on YouTube, and we have provided the call-in information both in the notice, in the published notice, the agenda, and live this morning. So everybody who wishes to come in to speak may do so, and of course the meeting is being live streamed. This is in full compliance with the governor's order, Mr. Wizinsky. But if I may continue.
Okay. I just want to say one thing is you advertised that you could allow 10 people, 13 people into the
Mr.
meeting.
Wizinsky, if you could
And I don't
please
see
speak,
anybody
we're
in
going to
there.
mute you here.
Then you
The meeting
advertise.
is open to public. We are going to mute you until
Okay,
it's your
I'll
turn to
stop
speak.
speaking. We'll go.
Thank you. Please continue, Mr. Zawinski.
Thank you. So where I left off before that was the reasons for the certificate of occupancy limitation related to the township and the Benzie Leelanau Health Department's determinations. Not much happened procedurally after that time until Mr. Wizinsky chose to sue the county and the township in early 2019. At that time, the Township and Homeowners Association was also suing Mr. Wizinsky to have his structure declared to be a nuisance. Shortly after the first federal lawsuit was filed, the Township Homeowners Association and Mr. Wizinsky had a settlement negotiation where Mr. Wizinsky was represented by legal counsel, and they organized a settlement agreement that is referenced in your packet. And that settlement agreement put a number of restrictions on the use of the structure, required it to be sold or removed within 3 years from the date of the settlement agreement, and also allowed limited occupancy. There were some other provisions as well, however, that if they were violated, the homeowners association or township could go and ask the court to accelerate the removal date for the structure. And that is what happened. Long story short, the township homeowners association went to the Leelanau County Court and got an order enforcing the settlement agreement. Mr. Wizinsky attempted to set aside the settlement agreement, and the Leelanau County Court declined to do so. That decision is now on appeal with the Michigan Court of Appeals. It is in the process of being briefed. I believe we're still maybe about a month out by the time the reply brief is due. And my experience with the Court of Appeals right now is that they're taking about a year from the time cases are briefed to the time they decide them. So that's where that is at. But in the meantime, Mr. Wizinsky's attorney on the first lawsuit and I had some conversations about this matter in the spirit of some sort of resolution. And as we were working toward that resolution, Mr. Wizinsky's attorney withdrew from the case for reasons I don't know exactly what happened, but there must have been some sort of breakdown in the relationship. And after that point, Mr. Wizinsky filed a second lawsuit against the county while the first one was still pending, as well as against the township and the homeowners association, alleging many of the things that are raised in many of the exhibits that are before you today. I mentioned to you that a few weeks ago, the magistrate judge in that case recommended dismissal of the case. And I do have an update for you as of last week. I believe it was Wednesday or Thursday. Judge Janet Neff granted, adopted the magistrate judge's recommendation in full and has dismissed the federal lawsuit. So both federal lawsuits are now dismissed. There's the opportunity to appeal, and there's a time period for that. But none of the litigation against the county is currently active at the moment. But the reason why this is before you today is because one of the arguments that I made in the lawsuit was that to the extent that Mr. Wizinsky alleged the taking claim, his claim was not ripe because he never came to this board to appeal the decision. And he also never went to the zoning board of appeals at the township to appeal the land use decision. Now, Mr. Wizinsky I think is very clear in his papers, saw that and said, well, now I'm going to appeal so I can defeat that argument. We reviewed the rules for this board and the appeals process, and it is surprisingly not that uncommon that there was not a timeline for appealing. There was not a 30-day or 60-day type of limit as you might see in some communities, but again, that's not as uncommon as you might think. So we decided to bring this err on the side of ensuring that Mr. Wizinsky gets his hearing and reviewing this, although we believe there are some significant changes that have happened since July of 2018, specifically the fact that there is a court order for removal of the structure. Now, Mr. Wizinsky did present to the county evidence that the Leelanau County or Leelanau Health Department did approve some alternatives for the sewer, that's water and sewer situation. But to date, he has not received a land use approval from the township. He is seeking an appeal at the end of October on that. But otherwise, that court order still stands, saying that the structure has to be removed. So you've got the posture of this is rather unusual, and that's something the board should take into account. But there is obviously a lot of history here, a lot of arguments being made, but I think that the board's primary focus should be on those narrow questions of the code interpretation that are presented in the notice of the appeal that follow the ultimate kind of conclusion paragraph that Mr. Wizinsky has submitted in one of his documents, asking about whether the certificate of occupancy should have been required at all, whether it makes any difference that it's a gazebo or a utility structure, and whether the limitation on use of the dwelling is appropriate. And it would also be appropriate for this board to consider the timing and the circumstances thereafter. So I think that's my general overview that I wanted to give you, and I am happy to answer any questions from the board or the administration. Otherwise, I would hand it back over to the chairman or Mr. Hooper, whomever wants.
Does anyone have any questions for Matt?
If not, next, we'd like to present Mr. Hunter.
Okay.
On the
At this
next
time,
agenda.
thank Matt. Mr. Hunter,
Okay.
Just for people who are watching, you may want to introduce yourself and what your title is.
Okay, I'm Paul Hunter, building official for Leelanau County. Mr. William Wizinsky filed an application for plan examination and building permit on August 10th, 1992 for a 12 by 14 and a 6 by 9 gazebo. The square footage is listed as 212 square feet. You can see that on attachment number 1, which also includes a copy of the building plans and the land use permit issued by Leelanau Township. However, a note on the file from February 1995 states, unable to check in final inspection until spring. Mr. Wizinsky then applied on February 21st, 2017 to alter and repair a gazebo listed as 480 square feet. See attachment number 2. With a note on page 4 of the 5 pages stating, will restore, repair gazebo as close as possible to the original intent of the original approved plans. A permit was not issued until January 26, 2018. See attachment number 3, at which time Mr. Wizinsky paid $299 and was issued a building permit, PB 180051, that was entered into the county permitting system by then building official Steve Hogan to do the following: residential utility structure, gazebo shed, 12 by 20, structurally support original structure design after storm. Okay. The permit was administratively finalized and completed by building official, myself, Paul Hunter, after an approved special inspection was completed by Charlie Sessoms, our building inspector, on July 11th, 2018. A certificate of occupancy was issued on July 11th, 2018. See attachment number 4. The certificate of occupancy contained the following words printed on the certificate: structure may not be used as a dwelling per Leelanau Township zoning administrator correspondence dated December 12, 2017, and Benzie Leelanau Health Department's certified letter dated August 13th, 2015. That's right on the certificate of occupancy. You can see that on attachment number 5.
Okay, Mr. Hunter, that's a critical point. Could you just restate that last statement again?
Printed on the certificate of occupancy were the following words: structure may not be used as a dwelling per Leelanau Township zoning administrator correspondence dated December 12th, 2017, and Benzie Leelanau Health Department certified letter dated August 13th, 2015. See attachment number 5. A memo from council, see attachment number 6, is also attached to provide a concise understanding of the ongoing litigation. Mr. Wizinsky is appealing the stipulation printed on his certificate of occupancy. The certificate of occupancy is an approval of structures that are built and permitted under the state of Michigan building codes. This approval is for the human habitation of these structures that includes, but is not limited to, pole barns, garages, tents, sheds, houses, apartments, etc. The certificate certifies that the structure was constructed according to the Michigan Building Code. So then I went on R202 definitions of an occupiable space. A room or enclosed space designed for human occupancy in which individuals congregate for amusement, educational, or similar purposes, or in which occupants are engaged at labor, and which is equipped with means of egress and light and ventilation facilities meeting the requirements of this code. R110.1 out of the building code, use and occupancy. A building or structure shall not be used or occupied, and a change in the existing occupancy classification of a building or structure or portion thereof shall not be made until a certificate of occupancy has been issued in accordance with the Act. R110.3, certificate issued. After the building official inspects the building or structure and finds no violations of the provisions of this code or other laws that are enforced by the Department of Building Safety, the building official shall issue a certificate of occupancy which shall contain the following: the building permit number, the address of the structure, a description of that portion of the structure for which the certificate is issued, a statement that the described portion of the structure has been inspected for compliance with the requirements of this code, the name of the building official, the edition of the code under which the permit was issued, any special stipulations and conditions of the building permit. Occupiable space is not to be confused with the definition of a dwelling unit as defined by Section 202 of the Michigan Building Code. R202, definition of a dwelling unit. A single unit providing complete independent living facilities for one or more persons, including permanent provisions for living, sleeping, eating, cooking, and sanitation.
Thank you, Paul.
You're welcome.
Thank you. Okay, at this time, we're going to move on. Bill, this will be your time to speak. Did you hear me, William?
Yeah, okay, I'm unmuted. Can you please allow me to share my screen so I can present exhibits?
Yes.
Okay, it says, okay. It says right here, host disabled participant screen sharing. Can you please let me present my documentation that I would present if I was there in person?
Okay, hold on a second.
Yes.
Yeah, we're in the process of doing that.
Thank you.
Share all, and then that will take care of it. He should be sharing.
All right, we should be all set here.
Okay. Here's my,
We have allowed it from our side.
what? It's not letting me open it. Let me see. Share, show all windows. Where is it?
I don't know.
Okay, I'm going to try to share, but it's not letting me. Hold on one second. Let me close this and try again. Okay, advanced file. Let me see if it'll let me do this. I was able to share it last night at a meeting.
We now have a screen saying receiving content.
Okay, it's still not letting me bring up my presentation. Let me see if I can. Let me see. Save as. See if I can get it in. I'm trying. There it is. Okay, do you have it?
Yes.
Yes.
Okay, these are my concerns about what's happening. This was sent out. This link only appears to work with my email and does not seem to work at all now. So people didn't have access to my documents. This link was not in the newspaper advertising, not on any of the pages on this page from the link above. So how do people know how to Zoom? Obviously, though, it doesn't matter because you're not allowing people to Zoom. And as of yesterday, you can see it, you couldn't even get in there. So all these documents have not been open to the public. And let me see if I can move this somewhere so I can read this. After 5 years and through filing a federal case, this is how we got an appeal. And this is my appeal and my guide to how Leelanau County, working with Leelanau Township, unlawfully forced my family out of the county after the adoption of our African-American daughter. This is the short version, and then I'm going to go through the appeal. After a 2015 storm damaged our home, in September 2015, the county red tagged our home, denied us repairs until repair permit issued. Then they simply refused to issue permit after several applications, Exhibit 19. In December 2017, the state of Michigan Civil Rights Division required the county to issue a permit for settlement of a racial discrimination complaint, Exhibit 11. In 2018, after our home was exposed to 3 winters, the county issued the permit with zoning approval, Exhibit 2. To keep African Americans out of the county outlawed us from sleeping in our home with a fraudulent certificate of occupancy, Exhibit 24. I tried to appeal, but was told there was no appeal process. I sent certified letters to all county commissioners, Chet Janik, Paul Hunter, and Joe Hubble, asking for the appeal. There was no response, and they should have sent me the appeal process at that time since I was looking to appeal it, but it never happened. Paul Hunter needed to entrap my family since we are on almost 2 acres and no one knows when we are using our property. 8 days after the certificate of occupancy, Hunter wanted a second inspection of our fireplace, Exhibit 53. Fireplace was inspected and approved, Exhibit 54. Hunter coordinated with the township the inspection so a private detective could report us sleeping in our home and let us sue us for litigation, Exhibit 52. The township sues for alleged zoning violation, sleeping in our home. The township violated the Open Meetings Act, the Township Zoning Ordinance, and the Michigan Zoning Enabling Act, Exhibits 27 to 30. Instead of a $100 fine and an appeal process, this cost us $25,000 in legal fees. In the forced settlement, we must sell our property, must move our home off the property in 3 years if it does not sell. Exhibit 3, 26 to 30, and 37. This document unlawfully denied use, thereby keeps my daughter from inheriting the property. Now, this is the meeting. Chugach County Commissioners, violation of the 14th Amendment due process, denied takings claim and disparate treatment and racist. Violation of due process, unlawful mandate by Chugach. This is Exhibit 19. At the meeting, this is from Mr. Patmore's notes of the meeting on 6/22/17. Steve Hagen was there, Ty Wessel, Chet Janik, and Steve Patmore. Okay, this is Leelanau County received a building permit application from the owner of, I think this was my second one, last fall, to replace structure. Now, that is a lie. Already repaired much of the structure, so application stated this. Did not state this. You just read it. Did not state replacing it. And the other issue is 9 months have passed and not processed. 2 winters passed. And this is the law, Blanche versus Benson Township, deliberately and improperly interfered with a process by which the township issued permits in order to block or delay the issuance of permit. Such actions, if proven, are sufficient to establish a substantial due process violation actionable under 1983, even if the outcome of plaintiff's permit was favorable. These are additional case studies. I'm not even going to go through them. Basically, you denied my due process rights by not allowing me to have a permit. Okay, now Mr. Janik basically states, I got to move you out so I can read it. First one, lie. No inspection since 1992. This was said sight unseen. No documented inspection and building is locked, so no inspection could have happened. Leelanau County has determined that the existing structure is in violation of the building code. How do you know? You haven't even seen it. The last time it was saw and inspected was in 1992, and Chet Janik said this. Chet Janik mandated my home to be removed, so no permit ever submitted would be processed. Leelanau County is mandating that existing structure be removed. Okay, now here's another lie. Commissioner Wessel and CA Janik concerned that the existing structure is being occupied. This is a lie. My house was open to I have not gotten my permit to even repair it. There's no way anybody could live in there. So this is another lie. PATMORES letter from June 22nd, 2006 meeting, Exhibit 12. Per our discussion this morning, a land use permit from Leelanau Township is required to replace an existing structure within the township, including replacing the gazebo structure we discussed on Lot 11 in the Shores subdivision. Another lie. I just spent a lot of effort and money repairing the home. Why would I want to tear it down and start over? You saw the permit said restore it to the original condition. Since my application did not state this, it means I do not need a new land use permit. This was an internal document. I was not to be copied. You can see it was copied to Doug Scripps, Ty Wessel, and Chet Janik. Okay, Chet Janik email threatening courts for non-existing violation, Exhibit 20. Steve H., based on the written confirmation, I'm assuming you will be sending out a letter to Mr. Wizinsky within the next week, notify him of the zoning administrator's decision and the fact that the structure is out of compliance, and therefore he needs to meet the current codes or remove the building within the allotted legal period. Failure to do so will result in the case being referred to the courts and the legal process will commence. This is how Chet Janik was going to get his mandate enforced through fraud. It involved zoning when zoning was not required based on the letter, because I was not going to tear down my house and rebuild it. I did not need a new land use permit and could use the 1992 land use permit based on PATMORES' letter. Steve Hagen issues a citation to get me to apply for an unneeded new land use permit, Exhibit 13. The provisions of this code shall not be deemed to nullify any provisions of local, state, or federal level. In reference to 6/22/2017 meeting, including Steve M. Hagen, building official Chet Janik, Leelanau County Administrator, Ty Wessel County Commissioner, and Steve Patmore, Leelanau Township Zoning Administrator, a land use permit shall be obtained from the township for reconstruction of the building to meet code compliance. This is how Chet Janik manipulated his people to get his mandate and require me to file for an unneeded land use permit. I did, and then it took 5 months for Patmore to deny the permit when his ordinances require denial in 45 days. His denial would be attached to the certificate of occupancy stating my home was not a dwelling and then we could not sleep in it. The township sued us for not getting a new land use permit and sleeping in our home. Mr. Patmore's denial email can become the basis for the restriction in the certificate of occupancy. The county cannot even issue a building permit unless you are in compliance with zoning and have a good land use permit. They issued my permit based on the 1992 land use permit. Van County and Township conspiracy to deny civil rights. If two or more persons in any state or territory conspire or go into disguise on the highway or on the premise of another, any act in furtherance of the object of such conspiracy where another is injured in the person or property or depriving of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damage occasioned by such injury or deprivation against any one or more of the conspirators. Now, the only reason I will be appealing the federal case, but the only reason the case was, I made a lot of mistakes because I'm not an attorney, but the case was terminated was because of the signed settlement agreement. And I filed a motion to have your circuit court judge turn it over, but he refused. And so the federal court could not overturn a decision of the circuit court. And that's why the case was terminated. Now, if the settlement agreement is turned over by anybody, then the federal case could be refiled, or I can use that in my appeal, or I can ask for the reconsideration for the federal court. And I will prove that the settlement agreement was fraudulent. Okay, the county and township conspired together, violating our civil rights to deny our property rights, deny use, and deny my daughter from inheriting our property. State of Michigan Civil Rights Division requiring county to issue permit of settlement of racial discrimination complaint. I received something from them that said the adjustment. The adjustment was referring that I'll just read it. Good afternoon. I'm sorry I was off yesterday. I'm out this afternoon, but yes, the adjustment, although very minor, was the permit. So that was the fact that the Civil Rights Department had to get me the permit. They basically, as for settlement of the civil rights claim that I filed against the county, they issued the permit. Disbarment treatment by the county. Amico versus Commission on Human Rights and Law. Once a prima facie case has been made out, the burden of a production shifts to the defendant. If the defendant articulates a legitimate, non-discriminatory reason for its actions, then the burden shifts back to the plaintiff to prove the given reason was pretextual. And I'm just asking is why why he mandated my home to be removed in Exhibit 19 without ever doing an inspection, sight unseen. If this is not racism, by what authority does he have to do this? Ask Chet Janik why he had to file a racial discrimination complaint to the State of Michigan Civil Rights Division, where their county was required to issue a repair permit for settlement. Is this how a Black family has to get their permits in the county? We were singled out by Chet Janik. Under Gay versus Waiters and Dairy Lunchman Union, explaining that disparate treatment cases require proof that the plaintiff was singled out and treated less favorably than others similarly situated. In 2015, the storm damaged a number of homes. Many of them were damaged. No one had got permits for the repairs because the building department could not get permits for repairs for everyone. Everyone, including myself, was told to make the repairs and get the permit afterwards. Now, I was red flagged and I was not allowed to continue making repairs, and they simply never processed my repair permit. And the only reason I got my repair permit was I filed a discrimination complaint, and they required the county to give me the repair permit. This disparate treatment is being treated differently. A plaintiff can establish an FHA discrimination claim under 3 of disbarment treatment or disbarment impact. This is Harris versus Itzhaki. Why no, it was racism. We used our property for 23 years without a single complaint. My neighbors tried to prevent me from repairing our home by telling every contractor they would be sued if they worked for me. In 2015, they denied the repair of my home. In August 2017, my daughter was in the Northport parade, and I realized she was the only person of a color. I called a county official whom I was known for many years, and he confirmed my daughter was the reason my permit was denied. That is when I filed the discrimination complaint. In August of 2019, a retired judge told me this. This is the judge that's from your court there in Leelanau County. Keep your family safe, get them out of the county, sell your property, and do not look back, except you will never be able to use your property again, and you can never win this in that court. And he was right. The court, just nobody could win. The court was in with a prosecuting attorney and the county. He was correct, and we will never return to the county. So we are never coming to your county because I do not want to risk my daughter's life or our lives. Wizinsky appeal for unlawful restrictions on certificate of occupancy based on violation of R110.3. Any restriction on a certificate of occupancy must be on the building permits first. You cannot issue a building certificate and, you cannot issue a building permit and not put a restriction on it that you're going to put it on the certificate of occupancy, because the people won't build it. If you said that I'm not going to be allowed to use my gazebo to sleep in, I wouldn't have built it. Certificate of occupancy. After the building inspects the building or structure and finds no violations of the provisions of the code or other laws that are enforced by the department, and all permit and planning review fees are paid, the building permission shall issue a certificate of occupancy that contains all the following. Yes, I got a certificate of occupancy. That means I'm in compliance with zoning. That means I'm in compliance with all the codes. I'm in compliance with everything. Any special stipulations, conditions of the building permit. So they need to transfer from the building permit anything onto the certificate of occupancy. If there is nothing on the building permit, they cannot transfer anything. They cannot put a restriction on the certificate of occupancy that is not on the building permit. It's that simple. 1992 permit exhibit 6 called gazebo, no stipulations. Gazebo. Building part knew it was to be used for me sleeping away because we live 250 miles away. The building inspector told me for me to sleep in it, I needed drinking water and a portable toilet. This standard was confirmed and is still used today in 2015 by the Health Department, William Crawford, Exhibit 34. The gazebo would not have been built if there was a stipulation denying use on the permit stating no use as dwelling, or we could not sleep in the gazebo. Now, are you seeing can you see this? Are you seeing this?
Yes.
Can you see what I'm my screen?
Yes.
Yes.
Okay, I just want to make sure I'm not just reading this and you can't see the screen and the exhibits, because I can't tell from here if you're seeing it. Okay, the 2018 repair pit exhibit 2 called gazebo shed, no stipulations. There's no stipulations on that either one. The building department, Steve Hagen, knew it was to be used for a sleeping place. We talked about it, how I was going to use it. He knew I was going to use it to sleep in. There's no doubt about it. He knew I used carried in water. He knew I had a chemical toilet. Mr. Crawford from the health department has kept everybody informed that I was allowed to use this property. I spent $30,000, $5,000 on repairs. If there was a stipulation denying use of cannot use as dwelling or sleep in it on the permit, we would not have repaired it. It's as simple as that. And my house still taxed today as a house. Despite being denied use, I'm paying taxes on a house. Okay, this is the fraudulent certificate of occupancy, Exhibit 24, call utility structure, stipulations on certificate of occupancy that are not in the permits, violation of 110.3, unlawful denied use, violation of U.S. Constitution. It's a takings claim. This is certified the building or structure has been inspected, constructed in accordance with the building permit, and found to be in compliance with the permit, the code, and other applicable laws and ordinances. County inspected and in compliance with zoning. So how can I get sued for a zoning problem when the county inspected it and it gave me a permit? In violation of 10.3, special stipulation and conditions. Structures may not be used as a dwelling per Leelanau Township Zoning Administrator correspondence dated December 12th, 2017, and Benzie Leelanau Health Department certified letter and dated August 13th, 2015. Okay, we're going to go through the different frauds. First of all, this couldn't be on the certificate of occupancy because it was not on my building permits. So that automatically just makes you have to take it off and redo this and change what I'm asking to change. But I want to show the fraud. Fraud 1. County, township, and the shores knew in full compliance with health department from FOIA documents received. When I filed my civil rights, my racial discrimination complaint, I got all the FOIA documents from all the other, from everybody. And you see, they were just not going to allow me a permit. Therefore, my building would come down and I couldn't use it. But because I got the state of Michigan Civil Rights Division and they were ordered to issue me a permit, they had to come up with another plan, which was falsify the certificate of occupancy. Okay, county township knew I was in full compliance. Letter attached to certificate of occupancy resolved in 2015. So you attached a letter from the health department that was resolved a few weeks later, and again in 2016. This is from Mr. Crawford, September 21st, 2016. Mr. Wizinsky, I got your phone message earlier this week and your written response, and I'm sending that the HD complaint matter is closed with my letter of September 13, 2016. You have any questions, please contact me. So the matter was closed. If the matter was open, the health department would close me down. This is a letter from, email from me to Mr. Crawford and everybody, Steve Hagen, Steve Patmore, Bridget Hart of the Shores. So everybody was aware of what was going on. Okay, so Joe Hubble, who's the prosecuting attorney, got involved in this. And he was fully aware that I was in compliance. He also sent him the letter. Mr. Hubble, attached is a response to my letter to Mr. Wizinsky. I find it an acceptable response. I'll be closing the HD complaint file on the matter. Let me know if you have any questions. Bill Crawford. From the detached letter in the email, and this is Exhibit 34 in the what I gave you. During our conversation, you would be willing to use a commercial chemical toilet on the site instead of the current rudimentary waste system, if that would allow you to use the property as you had previously done. I believe that would address environmental and health concern regarding this matter and meets the intent of Leelanau County environmental health regulations. So I'm in compliance. Okay, so there was emails back and forth between Hubble and Mr. Crawford, and all this has been copied to Joseph Hubble, prosecuting attorney, Steve Hagen, Leelanau County construction code official, and Todd Hooglin, the Shores Homeowners Association, by both mail and email. Everyone was fully aware with the health department. Additional evidence is in Exhibit 34. Mr. Hubble email sent on September 19, 2016 at 9:22 a.m. asked, what about the water? What about the lack of water system? Mr. Crawford responded the same day at 10:22 a.m. If there is no plumbing in the structure, where there isn't, from my understanding, drinking water can be transported in and out as needed. This is similar to our requirement tenting on a property. When the county issued the certificate of occupancy with the limit based on the 2015 letter, Exhibit 30, which was referenced, was an initial complaint letter. I immediately responded to the letter, and the health department dismissed the complaint with the follow-up letter and emails. All these documents are directly from county and township records through a 2015 FOIA request. Therefore, attaching a resolved issue by the department was fraud. They were aware of co-compliance. Fraud 2. County, township, and the Shores new house tax as a house, Exhibit 51, Patmore initialed. Mr. Patmore went and got the tax records. And it's not a very clear document because it's a copy of a copy of a copy. But on it, we are a single family ranch home. And I think it's class D10, which is a really low class. I mean, it's a summer home. There's no insulation. It's like a cottage. And it would have been used as the plan was, I built this in 1992. There was no place to stay in Northport. It's as simple as that. There was no place to stay. And so I built this to design my home. I'm a licensed architect. I'm also a licensed contractor. I have 40 years of experience. I don't make code mistakes. I don't violate zoning ordinances, and I would never do it on my own property. And so the point is it's taxed as a house. It's still taxed as a house today. And Mr. Patmore was fully aware, taxed as a home. He signed this in 6/27/17 when he decided a few months later that it's no longer a home. Fraud 2. So it's not a home, so they could sue us, but it becomes a home again as soon as they force us into a settlement agreement. The county, township, and the Shores new house was a house. Exhibit 3, settlement agreement, confirms house as a house, dwelling by township for settlement. Now, for a zoning violation, it's a $100 fine. It's as simple as that. I was supposed to, it's a law that I'm supposed to receive a ticket and a $100 fine. And then I am supposed to be able to appeal that. And I never was allowed to appeal it because they sued me directly. And this is what instead of a $100 fine, this is what they made me do. Defendants must list their property for sale within 30 days of this date of this agreement for a alleged zoning violation. This is a requirement for the remedy for suing us, that we have to sell our property. If I do not sell the property, in 3 years, we have to move the home off the property to deny use of the property. As a professional in the business, I could not believe this could happen. This was a requirement for settlement of an alleged zoning violation. We have to sell our property and move our home off the property. Their zoning ordinance state $100 fine, not litigation. If the purpose was not racism, why is it? They were required to issue me a $100 fine. Okay, now they allow defendants may dwell on the property for no more than 18 nights per year, starting the Friday of Memorial Day and ending on October 31st. Steve Patmore will be notified 3 days prior to any night stay. My neighbors wanted to know when there was a black in the community. And that's why we had to do this. When I showed this to people in 2019, in August, and the judge, people were appalled. This is not Nazi Germany. It is a dwelling again, but why are there a limited number of days, and why must I give notice of 3 days that I'm using this property to Mr. Patmore, the zoning official? The township, the zoning department, or the protective restrictions have no zoning ordinances or authority to put these restrictions of use of property, specifically when I'm being taxed for a home for a whole year. Defendants agree to no short-term rentals. So, how many people rent out their tiny sheds in the middle of the woods that's hard to get to as a rental unit? How many sheds, short-term rentals of sheds occur in the middle of the woods? Again, just showing that township recognized the home as a dwelling or vacation property and has commercial value as a weekly rental, not a utility structure. It appears we have the right for a long-term rental on his home. So they're calling it a home because I could rent it long-term. There are no but as long as we do not use the home for more than 18 days a year. They only want us there 18 days a year, and then we have to tell them when we are coming. In the motion that I violated this document happened after I made an appearance in August of 2019 and handed out a brochure to 300 people, and I raised a ruckus. But the reason I lost the motion was because I gave Mr. Patmore a week's notice versus 3 days notice. And the judge noted I was not in compliance because I didn't give him 3 days notice as required under the law or the agreement, not a week's. Yeah, this is happening in your county. Okay, there are no deed restrictions or other acre restrictions. I'm not going to get into the rest. We'll get into the rest later. So there's a problem. How do you enforce a person sleeping in his home on 2 acres of land and it's covered in trees and you can't even see the home? Can't see it from the street. How do you enforce it? I talked to an attorney about this. He said, "They'll use your home. There's no way they can enforce it. They can't see you sleeping in your home. This is a ridiculous thing. And it's a fine. If you get caught, it's only a fine." But that was their problem. Our home is hidden in the woods on almost 2 acres. This is what Mr. Hunter said. Just an update. Exhibit 53, per our conversation on 7/11/18 at your property, a permit is needed for the wood stove in your structure. Installation instructions are required at the time of the inspection. Well, he approved it on 7/28/18, exhibit 54, and you can see it's a fireplace. How many sheds have fireplaces in them? So our house is hidden in the woods on almost 2 acres. No one knows when we are even there. This presents a problem to actually see us sleeping in the home. It is impossible to enforce unless you trespass, kick in the door, and see us in bed. They can only make an assumption we slept in our home. The email was sent out 8 days after the issuance of the certificate of occupancy to lure us up north. Hunter then contacted the township so they could hire a private detective to catch us sleeping in our home. The inspection occurred on July 28th, 2018. The detective reported exhibit 52 was an exhibit in the litigation. We were spied on July 29th and 30th, and the detective met with the township and lawyer on the 31st so they could start the lawsuit. This is the exhibit 52 that was used in the litigation, and I'm going to go into part of it. Report for July 29th to July 30, exhibit 52, private detective report. Mr. Hoogland, asked if I could come out to the scene to be a neutral party and witness that Mr. Wizinsky and his family are spending nights in the temporary structure in violation of law. Mr. Hooglin escorted me near the property, the adjacent property line. You got to remember, this is night in a heavily wooded woods. Mr. Hooglin pointed to the location of Mr. Wizinsky's car, illuminating it with a flashlight. It was just located just east of the structure. Mr. Wizinsky's vehicle was still parked in the driveway. It is apparent that Mr. Wizinsky and his family were spending the night in the interior. The building was all dark. July 31st. It should be observed that it was parked in the same area as it was parked in the night before. So I get sued for this. There's no proof here. No one saw us sleeping in the home. You can't prove that. Okay, there are a lot of assumptions that we were sleeping at home. No proof, just that Chet Tanik and Ty Wessel stated, Commissioner Wessel and concerned that existing structures being occupied. The house was not repaired. It was open. There's no way anybody could stay in there. It was fully open for 3 years. It rained and it snowed in the house for 3 years. We come to the property with 2 cars before leaving, one on the property and one in town. In the complaint Todd Hooglin made to the health department, we were living on the property. The place was not usable, but we left 1 car on the property and 1 in town. The car did not move because it was there, and the place was dark because we have no electricity. We also could be down at the beach. We could have a bonfire on the beach, and we're not on the property when the detectives saw the building dark. We also could have been sleeping in a tent when we were finishing up repairs on the home that they did not see on almost 2 acres of forested land. They flashed a flashlight at the car through the woods some 50 feet from the car at night and said no one was in the car. We have slept in the car before when we arrived late and when repairing the building. We have tinted windows, and when in the SUV, they could not see us. My wife said she had seen before someone flashing a flashlight at a car at night when we were in it. There is no way to prove definitively we were in the building sleeping. There are more possibilities our car was in the drive and the building was dark. This is also from that Exhibit 52, meeting with township officials on the 31st. On Tuesday, July 31st, I attended a meeting at Leelanau Township office at 11:30 a.m. Present were the following township officials: Township Supervisor Doug Scripps, Township Zoning Administrator Steve Patmore, Shores Board members Todd Hooglin and Randy Hammond, Shores owner Steve Holmes, Attorney Zietz, and the Shores Association. The report wasn't even written. And they were figuring out how to sue me. Based on the fraudulent certificate of occupancy, my family was sued directly for sleeping in our home based on an alleged zoning violation. The township violated the Open Meetings Act, the township ordinances, and the Michigan Zoning and Enabling Act. The rule of law was ignored, and we were treated with disparate treatment. Instead of a $100 fine, we spent over $25,000 in legal costs. There are 2 systems of justice in Leelanau County and Leelanau Township, a white one and a non-white one. A zoning violation is a $100 fine. We spent over $25,000 in legal costs. We were told the court will protect the public officials and their policies. Our house was broken into and vandalized. Joe Hubble said it was a civil matter. When is anybody's home broken into and vandalized a civil matter? Oh, that's right. It's a criminal matter if you're white. If you're black, it's a civil matter. I was told by Hunter that he was ordered to prepare the certificate of occupancy by Joe Hubble. So the prosecuting attorney was involved framing us. I contacted the Attorney General's office and they told me that I have to file complaint with the prosecuting attorney, Mr. Joe Hubble, to prosecute Mr. Chet Jenick and Hunter and the township folks for violating the law. And you know what? I don't think Joe Hubble would do that since he's assisting them in violating the law.
Point of order, Mr. Chairman. We are here as a board of appeal. His issues are with the township.
I'm not done. Mom, I mean, excuse me. I have to show you the rest of it because I'm not done with my appeal. I'm just gonna finish up. There's only a few more slides. What we were concerned with and why we signed the settlement agreement was if we stayed with the black system of justice, we or our daughter could be framed, sentenced, and jailed for a criminal frame-up. That's what we were concerned with. The purpose of the liquidation was for intimidation and force us out of the community. It worked. We are gone. So we fulfilled Mr. Chet Jenick's mandate that he had said in the June 22nd meeting he wanted us removed. This is an affidavit of Carmen P. Avanti, a zoning expert witness. Am I still being heard?
Yes, but we should stick to the.
I have 3 more slides. It all goes to my point.
Do they pertain to this appeal?
Yes, they exactly pertain to this appeal. When the Wizinskys were sued, and let me finish up. I got a few more. When the Wizinskys were sued, citing the nuisance per se section under MCL 125.3407 and 10.6 of the township zoning ordinances, the state act and township zoning ordinance required a fine or citation first, not direct litigation. If there was a violation, a fine should have been issued per the MZEA. The township ordinance section 10.6 also required a fine. Municipal civil infraction. A violation of this ordinance is a municipal civil infraction as defined by Michigan statute, and she shall be punishable by a civil fine determined in accordance with the following schedule. Now, why this all has something to do with the certificate of occupancy is because I was sued based on the certificate of occupancy stating we slept in our home. That's why this is all part of it. Conclusion. Based upon the above information, by suing the Wizinskys directly, this is the conclusion by the zoning official. Without seeking administrative remedies, the Leelanau Township denied them the protections and due process provided them under the MZA and the township zoning ordinance. Now, under the Open Meetings Act, the MZA, and the township owned zoning ordinances, I'm supposed to have an open meeting. They didn't have that. And I want to show you how the township covered up that they were going to sue me for sleeping in my home directly. 9/11/2018, closed township board meeting. Exhibit 28 and 29. Closed session. The purpose of this closed session is to discuss Foxview Homeowners Association request. Okay. So they have that on the agenda. Then they say motion passed in a closed session require Foxview Homeowners Association request. Act on discussion from closed session. Motion made by Dunn, second by Van Pelt to join the Shores Homeowners Association as a co-plaintiff concerning zoning ordinance violations, as recommended by the township attorney Seth Koch. Motion passed 5-0, exhibit 29. That's the only meeting minute because it was closed. Township board knew they were committing fraud and tried to cover it up by falsifying the agenda with Foxview HOA. There is no such HOA, so nobody could care and then not attend. There is no notice about Lot 11 or a zoning violation, where both would also require an open meeting. They got the Shore's name correct in the actual motion for legal purposes, but just above the Foxview name. The township knew they were violating the law and were disguising it. Concerning zoning violations is the only public record of an alleged zoning violation. There is no other record than the filed litigation by the township. In doing this, the township violated the state constitution based on your violation of the federal constitution by falsifying the certificate of occupancy. The litigation had been two separate lawsuits, but they needed a method to funnel public funds into or to share the cost of the litigation by the Shores. The Shores wanted me gone, but could not afford a frivolous lawsuit. Todd Hooglin and Doug Scripps are good friends, as per Amy McDonald with the Civil Rights Division investigation. Under the state constitution, Article 9, paragraph 18, the credit of the state shall not be granted to nor aid of any person, association, or corporation, public or private, except as authorized in this constitution. The retired judge concurred the money was embezzled since there was
Mr. Chairman, this is an obstruction board of appeal.
Yes.
We have no authority on township zoning issues.
Okay, I'll go on to the next one.
Mr. Wizinsky has 2 slides left. He's on slide number 6. He needs to stick to the topic of the meeting, please.
Okay, this is let me go to this one. Okay, well, you are involved in this because of the permit. This is you, and this you can see it says Hogan on this email. So I have a right to present this evidence to you. No zoning violation. I built exactly the Mr. Patmore specification, Exhibit 15. Steve Hogan. It also, Chet Jenick got this one. You can see right here, not Chet Jenick, Doug Scripps. Sorry. And it has a letter construction. Mr. Wizinsky, just to be clear, consistent with my letter to Leelanau County in June 2017, attached a land use permit is required to remove and replace an existing structure. This also included changing the footprint of an existing structure. A land use permit is not required to remodel an existing structure with no change in footprint or height. So we had several discussions, Steve Hogan, your guy, Mr. Patmore, and me, that if I kept it in the same height, and if I kept it in the 12 by 20 foot footprint, I did not need the 2000 and a new land use permit. And that is why you issued me the permit, because you can't issue me a permit without a land use permit. And you can't issue me if I'm not in compliance with zoning. Okay, so it says here, a land use permit will be required to reconstruct these tracks. So, okay, documentation submitted to me shows that the original 1992 structure included exterior steps on the structure up the main level. At some point, these steps were removed. Yeah, they were removed by trees falling on them. Yeah. And so I have to get a new land use permit to replace my existing stairway that's been there for 23 years and on the original permit. So that's what, I didn't remove them. The trees removed them. Okay, so On the plans that were approved by your department, building department, the county incorporated PATMORES requirement in the plans, Exhibit 16. The stairs and deck were on the original plans and used that way for 23 years. PATMORE believed putting the stairs inside the house rendered the 12 by 20 home useless. So I talked to Steve Hagen how I could put a stairs in there. We talked about a spiral stairs. We talked about what I had to do to be in compliance to get my permit. So I put a full 2-code stairs in the house and lost 40% of the space. A full 2-code stairs took 40% of the interior space. The building inspectors were shocked that I was still able to make a functioning home. The building department in the certificate confirmed compliance with the codes, the approved plans, and zoning. The county denied me an appeal in 2018. I called the building department immediately after the certificate of occupancy was issued and was told there was no appeal process. If I was told there was an appeal process, I would have appealed it. But instead, I was told there was no process. Thereby, I mailed a certified letter to every county commissioner and received the green cards back showing it was received. The letters were also copied and certified received to the building department, Paul Hunter, Chet Jenick, and Joseph Hubble. I requested the decision be reversed and no one responded. The building department should have confirmed then from the letter and sent me the appeal process documented in August of 2018. I had to file a federal lawsuit to have this appeal today. That is how I'm getting my appeal. Your lawyer told you that he said I didn't try appeal. Well, I tried to appeal. And this is from the letter. I was informed that the decision to not deny my family their property rights was by your office. I'm referring to the county commissioners. With order to Chet Jenick with input from Mr. Hubble, the prosecuting attorney, your fraudulent portrayal of the gazebo as a utility building does not even coincide with present day legal zoning language. We have a fireplace in the gazebo that has just been permitted and approved by your building department. How many utility sheds have fireplaces? Please explain to me how Leelanau County commissioners, county supervisor, and prosecuting attorney are any different than the Coleman Young administration when you ordered your building department to reclassify the structure, add letters from their conspirator, and a 2015 letter on a resolved health code issue based on fraudulent complaints. Please correct the record on your own. I got no response. And let me explain something that happened in Detroit. I built a hotel. I designed and built it, and I had to leave because the building.
William, that's not.
Okay, I'm okay. I'm just trying to explain. That's fine. When public officials order building departments not to follow the building codes, there's problems. In Detroit, there are a lot of buildings built because it was cheaper to pay Coleman Young the money than to have the building department comply. Please restore my property rights. Therefore, I'm requesting, if certificates of occupancy are not issued for accessory buildings, please remove the certificate of occupancy from the records and issue an approval sticker for a final inspection and record it in the records. If certificate of occupancies are issued for all structures, change the 2018 permit to gazebo, change the certificate of occupancy to gazebo with no restrictions. The restrictions have to be removed because they were not on the 1992 permit or the 2018 permit. The restrictions were fraudulent because the health code issue was resolved in 2015 and 2016, and the township sees the building as a rental unit. Therefore, I request you restore my property rights. I'm done. Is there any questions?
Yeah, right now, you asked if Chet, well, we should ask Mr. Yannick about
I'd like to respond,
something.
yes,
Would
Chairman.
you like to respond?
Yes, please, thank you.
Okay, hold on, let me stop the share.
And I'll keep my comments fairly short. Couple points here. One, Mr. Wizinsky did file a complaint with the Civil Rights Commission. The Civil Rights Commission interviewed myself, a couple other people, and completely dismissed all allegations against us. There was actually no follow-up from them. They never ordered us any to proceed. It was a simple dismissal of all allegation based without merit, and that's a documented fact. We had no discussions beyond when the Civil Rights issued their order that the case was dismissed without merit, and there was no mandate for any permit. That's a critical point. Secondly, I think all of you know, there's different forms of government. Leelanau County government is separate from Leelanau Township government, which is separate from the health department. We had no authority to interfere with the township or the health department. Much of what Mr. Wizinsky pointed out is issues with the township. That is completely separate. We had no authority. Can we have dialogue with them? Absolutely. I also deny the fact there ever was any open meetings violation. We have certainly every right to meet with individuals and discuss issues. Yes, we met with Mr. Patmore. That's not a meeting. It was a discussion, perfectly legal, and we proceeded. Mr. Hubble never ordered Mr. Hunter or anybody else to issue any kind of permits. His involvement was very casual. It was only based on the fact that Mr. Wizinsky threatened a lawsuit. When it comes to the issue of racial discrimination, which Mr. Wizinsky keeps pointing out, when I was interviewed by the Civil Rights Commission, I stated under oath that we had no knowledge of him having a family, a wife, a daughter, much one that's black. It was brought to our attention only by Mr. Wizinsky. So once again, that was a complete inaccurate statement by him. Once again, that case was completely dismissed and never any order and no follow-up to issue any permit. I can tell you when we met with the township officials and with the health department, no one in the room knew Mr. Wizinsky was married or had a daughter, much one that was black. That was a complete surprise to us. We only were notified that from Mr. Wizinsky. In terms of the lawsuit, our attorney pointed out the fact that it was dismissed. We never sued Mr. Wizinsky. We never entered into the lawsuit. Much of his allegations, as he said from his presentation, is issues with the homeowners association and the township. We are not involved with those. We were not part of the lawsuit. We did not enter in those negotiations. We were sued by Mr. Wizinsky. We never sued Mr. Wizinsky. We never were part of the lawsuit. We were never part of the agreement. We were never part of any dialogue with the township or the health department. I think that's a critical point there. And I said, Mr. Hubble only was involved as a county prosecutor because legal action was threatened against the county. Any questions about my comments? But I want to clarify that. Once again, I repeat, Civil Rights Commission completely dismissed Mr. Wizinsky's case without cause, without merit, never ordered us to issue any type of paperwork. There was absolutely no follow-up from them, other than the fact that they dismissed the case against us.
May I respond to that, please?
Okay.
Yes, I was told by Amy McDonald that and it's Exhibit 11 that they required for settlement permit to be issued. Had I not filed the discrimination complaint, I would have never gotten my permit. You could see that Mr. Janik mandated the house to be removed, and he was never going to allow me to have a permit anyway, no matter what.
Okay, point of order. I have no authority to issue a permit. I'm not a building official. I never mandated anyone on any permit, nor was I even involved with the discussions. I'm the administrative liaison to the building department. I am not an inspector. I don't issue permits. I do not deny permits.
You were at a meeting where you mandated the home to be removed. You at a meeting that you notified 9 months that the permit hasn't been processed. Why wasn't the permit processed 9 months earlier?
I'll respond only to questions from the chairman.
Okay.
Mr. Chairman, I'd like to have our legal counsel say a few words if he has any comments on this,
All right.
since he listened in on the discussion. He's our spokesman.
Yes. And Mr. Chair, yes, obviously I've been listening to everything that you have. We are not only in territory that, as the chair and Mr. Janik have correctly noted, is going far astray from what the actual issue is in front of the board today. But throughout the past hour, these allegations that have been coming out about the racism, about disparate treatment, discrimination, conspiracy, denial of an appeal in 2019, all of this was presented to the federal judge in the federal lawsuit. If any of it had any legs, she would not have dismissed the lawsuit.
She kept all the state claims. She dismissed the lawsuit. Let me finish. She dismissed the lawsuit because of the settlement agreement.
Mr. Wizinsky.
So the reason that the federal court did not do anything with the state claims, she dismissed them without prejudice, which does mean they could be brought back in state court. That is because of a procedural mechanism in the federal courts called supplemental jurisdiction. If the federal court dismisses all the federal claims in a lawsuit for reasons of lack of standing, lack of subject matter jurisdiction, or failure to state a claim at the early stage of the litigation we're in, then the relevant court rules and interpretations of those rules require the court to not address the state claims, to dismiss them without prejudice. So she did not make any findings on the merits or the viability of those state claims. But to the extent that everything here was presented regarding, denial of appeals or due process or conspiracy, all of that was presented to the judge. And I would point out, as I pointed out a few of the points in my memo to the board, at one point, the magistrate judge noted that Mr. Wizinsky, quote, made what appear to be false allegations about the Michigan Department of Civil Rights investigators' findings regarding his discrimination complaint, and asserted again apparently baseless claims of racism and discrimination by not only the county, but also the HOA and the township, end quote. In addition, she noted that Mr. Wizinsky, quote, falsely alleged that the county was somehow involved with the state court case, end quote. So many of the claims were so ungrounded in fact, according to the magistrate judge, that she granted my motion to find Mr. Wizinsky to be in violation of Federal Rule of Civil Procedure 11, which requires complaints to be made with a basis in fact and for non-frivolous reasons. She granted that. Judge Neff signed off on that. And while I asked for a monetary sanction, it was denied because Mr. Wizinsky was representing himself, essentially. But, for all this background, number one, it's not within the jurisdiction of this board to decide any of these issues, certainly not the stuff about the township and the homeowner association. And at the end of the day, these legal questions on all the case law, that's for the courts to decide. And in the federal context, they've already been decided. And we can sit here all day and talk about future actions and whatever it would be. Needless to say, I disagree with Mr. Wizinsky's interpretation that, having this hearing suddenly changes the nature of the federal litigation or future cases. But that's not what's before us today. And I would encourage the conversation to shift toward the code issues that are before the board today.
Okay, and that's what I'm stating is the fact that I was the only person in the county that was denied to repair my home. And it sat open for 3 years. in the winter? How many people in the county from that storm was denied a repair permit and had to have their home exposed to the weather for 3 years? Isn't that being treated a little differently than everybody else? And because Chet Jenick said he mandated the home to be removed, I mean, it's his right, his decision to do that. But we doesn't have that kind of authority.
Yeah,
But he blocked, but let me finish. This goes to the reason the certificate of occupancy was falsified. It's a felony to falsify. It's a state felony to falsify a public document. And that is one of the things that I can refile. I don't want to sue you again. I want you to restore my property rights. And if you don't restore my property rights, I will file an appeal in the appeals court. There's a direct process to do that. And all I'm asking is, let me finish. All I'm asking is for you to change the certificate of occupancy to a gazebo, if that is the way you do things up there. Here, down here in our area, we would not even get a certificate of occupancy. Only the primary home gets a certificate of occupancy. But up there, I know you do things differently. I think Benzie County gives out a certificate of occupancies. So if you give out a certificate of occupancy, I want mine to say gazebo on it, and I want the restrictions removed because they were not on the permits. They were based on fraud. Number one, I was in compliance with health. And number two, the township sees the house as a house, it's taxed as a house. And the township in the settlement agreement sees it as something that's rentable, as a vacation house. So that they can't call it a shed or not a dwelling if they're allowing me to rent it in long-term rentals. Okay, I'm done.
Mr. Chairman, by point of order, the next point is board discussion. That just gives you a chance for you to have dialogue and for you to ask questions, not for the people to ask you questions.
Okay. Okay, we're gonna move on. All right. Any of you have questions?
I don't have questions, but I may questions. My understanding that as the Board of Appeals, that we are to relate our comments to what affects the building code of our county.
Correct.
90% of what was presented was not part of the construction code.
I agree.
It is not, you do not relate to anything relative to the township or to the different court municipalities. It's to our own building department of this county. Is that correct?
That's correct.
Okay. Well, that said, and what Matt said, it is not the jurisdiction of this board to the matters that were related to judges, townships, areas. I want to make sure that we define our comments to that location, not go out of bounds of our responsibilities.
That's our responsibility, just to the building.
Okay, with that, I refer back to Paul Helmer's statement that, now, the occupancy is a question. Is this occupancy, part of my concern is that we have two definitions that Paul presented, they're straight out of the building code. And one of it appears that this structure is being used as if it had permanent facilities for living and to sleeping, eating, cooking, and sanitation. in electricity, water, and an approved sanitary system. I did not see that presented in that way.
No, I agree. In 1992, when we took out the permit, it was for a gazebo, and it was a screen structure. For some reason, it was decided that it be taxed as a residence, a house.
Then,
How did that change?
well, whether it's taxed as a house, that's not our problem.
Yeah, that's not our
I know it's not. What I'm saying is, something was done to the original structure to be identified as a house. I mean, even Mr. Wizinsky is calling it a house. I'm saying it's not a gazebo anymore. He did something to it without the knowledge of the building department to have it defined as a house.
It was billed exactly to the building department. Yeah,
Excuse
fine.
me, this is a discussion between the
Okay,
board.
I'm sorry. I'm just letting you know it was built and it was approved.
When it, all right.
So I'm basing my understanding and opinions as it relates to the building code. And in questioning that this is not a dwelling unit, it is not to be referred to as a home.
That would be my thoughts too.
A reference to a home would, otherwise says dwelling, a single unit providing complete independent living facilities for one or more persons with permanent provisions for living, sleeping, eating, cooking, and sanitation. So, I won't say more at this time about that.
Okay. Well, do you have any?
Well, I read this 3 times and I still don't know if we're supposed to call it a home or a gazebo or a shed. So I don't know if Chad or somebody could.
What's the question?
What are we supposed to refer it to? I mean, is that decided or is that, I mean, I don't want to get legal.
I believe just a structure, right, Paul?
Just a structure.
By code, what's the depth?
What his is defined as a structure. Glenn, I'm not absolutely certain your question.
Well, it keeps coming up in here. I'm wondering if we change the word, would it help anybody or be legal or illegal? Or what difference would it make if we change the name?
Mr. Chairman, could I weigh in for a moment?
Yeah, that's probably your question.
Yeah, there's really 2 separate issues here. I mean, Mr. Wizinsky keeps raising the point about this idea that it was taxed as a home and therefore should be a home. That's a bit of a misnomer. Under the tax classifications, it's taxed as residential property. But keep in mind too, even if there was a tax classification for home, there are plenty of situations where a structure may be classified for tax purposes as one type of use or another, but is not certified for occupancy. The tax system and the building code enforcement are 2 separate systems. So it's certainly, I've been doing land use law for my entire career for over 12 years now, and there's plenty of situations where you have a tax assessment on a parcel that is vacant or that has been declared as a nuisance or is about to be demolished. So that in and of itself does not have any bearing on what is classified as for tax purposes, does not have any bearing on the building code. What Mr. Wizinsky is trying to raise here, the question as I understand it, is that he is challenging the fact that the structure was classified as a utility structure. He would like it to be classified as a gazebo. I think one of the questions before this board today is whether that makes any difference. And that is what I would present to you as part of your discussion. And then the occupancy, Mr. Hunter has also raised the issue of there's occupancy and then there's dwelling use. you can occupy a structure for a variety of purposes, one of which may not be for a dwelling if it didn't meet those requirements. So these are the issues that are before you, I think, most clearly today.
So I understand it could have a different classification in a different setting, doesn't really affect us. I mean, the building department could call it one thing and somebody else could call it something else, that doesn't really.
Well, within the context of the building code, it's for you to determine what it is, but for tax purposes, under the Tax Act and the State Assessing Manual, it's not taxed as a house or as a utility structure. The property is assessed as residential property. What's on the property, they do their drawings as to what's on the property at any given time, and they might refer to something as a house or as a structure, but the driving characteristic for the tax law is that residential assessment. Is it residential vacant, residential improved, residential single family, which is separate and distinct. It's just a different classification system than what's going on with the building code. So I don't know if that's a satisfactory explanation, but that's the tax system is a higher level of generalization, you might say. It's more general. And of course, again, in this case, I think the question is, does it make a difference even under the building code, whether it's a gazebo or a utility structure?
I do have the definition of a dwelling based on the township zoning ordinances, which will clear it up. Dwelling, and I can show it to you, but for some reason I can't. Did you shut off my ability to show it to you? Or I can just read it. Dwelling, any building or part of it occupied or rented as the home, residence, or sleeping place of one or more persons, either permanently or transiently. Single family dwellings, a building containing not more than one dwelling, for residential 2-family dwellings. I don't need to get into that. But the concept, a tent is a dwelling. We used our home as a tent. That's how we used it, buried in water, and we used it that way for 23 years without a single complaint. And the fact is it was going to be used as, there's also another definition. Let me see if I have it in here. Guest house. We have to use the definitions that the township uses because that is what they, here it is, guest house. Guest house is called sleeping quarters with or without kitchen and bath facilities, located on the same premises with a main building and occupied for the sole use of members of the family, temporary guests, or persons permanently employed on the premises. Now, in the township zoning ordinances, you can build a guest house first before you build your primary home. Then in 1992, they didn't have any special requirements, but in 2018, nowadays, you have to give them a plot plan where you're going to build your primary home and where you're going to build your guest house. I built my guest house so that I could come up here as an architect and design my primary home to the land. And then I used it.
Why didn't you call it a guest house at that point? Why did you call it a gazebo?
Because that's what your department labeled it. It was a tree house. If you look at the drawings, it was attached to the trees. And I called it a tree house. Your department stated it did not meet VOCA requirements for foundations. So I built between the trees. I reduced the size of it so it would fit more easily between the trees. And then I put foundations down to the ground and built it exactly as he told me how to build it. I drew right there when I was there on the plans, which I think is one of the exhibits, if you want to look at it, that shows you see the original drawings were attached to the trees, and then I put in an alternate foundation system. The alternate foundation system shows 4x6 going down to blocks in between the trees. And that's why he labeled it gazebo. I did not label gazebo. I called it a treehouse. He said we can't call it a treehouse because you cannot connect to the trees. It's a BOCA, it's not an approved BOCA foundation. So that's how that came about. He called it a gazebo.
Okay, and then, but in 2015, you applied for a permit, said restore gazebo as close as possible. How did it change?
Because that's what it was labeled.
12 feet, 408.
I'm sorry, what was that?
Said, when you applied for a repair permit, I guess it would have been, how did it change from 212 square feet to 480 square feet? And you said on the permit, you were going to restore the gazebo as close as possible.
That is what I, basically, Steve Patmore told me not to issue a third permit. He took my 2016 permit application and changed it into the 2018 permit. And that's what I was trying different ways to get a permit, and it was clear I was never going to get a permit. The 2018 permit, what happened was I had 5 trees on my house, and I was not allowed to take them off. The shores blocked every person that was coming to my property to take the trees off. I spent $4,000 in legal fees to hire an attorney, to work with their attorney, to allow me to have someone go on my property and take the trees down. And after we came to a conclusion that I had a right to build a path to the back, take the trees down, and repair the home by their attorney and my attorney, the Shores people continued calling every person that came to my property to take the trees down, that they were going to sue them. What happened one time near the end, I mean, it might have been late August, a person came in a truck that didn't have any markings on it. And so he came, he was more expensive. He was from Traverse City, and he was going to take the trees down. So in the meantime, as an architect, I didn't want my building to collapse. It's a lightweight structure. And what happened was I had the weight of the trees on it, and we had another storm. I had to reconnect all the ground support and restructure the entire lower floor to carry the weight of about 50,000 pounds worth of trees. And I had to add new foundations in because I couldn't get the damn trees off. I was making repairs on my home with trees on it. And there's an engineering letter in the application that Steve Haugen wrote that was part of the application stating I had to do this to save the structure from collapsing. So there was a first floor created for the purpose to keep that was created with the trees on the building. And the only reason I got the trees off was because a guy came in a truck. It was Al Piers out of Traverse City. And the day they came to take the trees down, they were called and said they'd be sued. The guy was there with all his big equipment and his crew, and he started the work. It started to rain, so he had to come back another day, and the Shores says they were going to blockade him from coming back to take the trees down. This is how I was treated in 2015. And so then your guy red tagged my building after I got the trees down, but it was not repaired. And then it was sat there for 3 years until I got my permit through the State of Michigan Civil Rights Division.
Point of clarification, the Michigan Civil Rights Commission had no input in it, and that's been proven, and that's been stated in court, and I wish you would quit saying that, because it's completely false. The Civil Rights
Because
Commission quickly dismissed the case.
if you look at the
Thank you.
exhibit of Amy McDonald, I think it's number 11, that shows that they got me the permit. It was part of a,
No, this is for our discussion here.
Yes.
You answered my question that I asked you personally.
okay, thank you.
Discuss this. George, did you have any? He's muted.
George, could you unmute?
All right, I have no comment here. Much of what I've heard here today, though, is confusing. You bounce from one subject to another, and having read it really recently, I think I'm not convinced that what he's saying is correct. And he talks about a homeowners association, and I don't know what kind of agreements he had with them, but he's got to get the agreements through them to the county board. I believe that's the only comments I can make right now.
Okay, thanks, George.
Mr. Chairman?
Rich,
Yes.
I have some comments. This discussion previously was spoken of definitions of a space by the township. That is not our definition's responsibility as the board relative to the construction code laws, which bases the definitions on the building code. The township definitions are not that.
Mr. Chairman?
Yes.
May I speak?
Yes.
Thank you. Well, first of all, I want to thank the four of you for giving up your Monday morning to be here. We appreciate your service, but it's quite simple. You are the Construction Code Board of Appeals. That is your duties. You are here for one reason, and it's right on the agenda. It's to hear the appeal of the terms of occupancy. The department made a decision, issued a statement. Mr. Wizinsky is appealing it. Your job is simply to either agree with the appeal or simply deny the appeal of Mr. Wizinsky. I mean, it really is that simple. You've heard arguments for 2 hours now. Once again, we appreciate your service. But really, the discussion about the township, about the health department, about civil rights has nothing to do with this case. As I stated, you are Construction Codes Board of Appeal. You are here because there was an appeal made by the terms of certificate of occupancy. Your job is simply to either agree with the defendant or deny his appeal. If you agree with it, then we can go further discussion. But really, I think it's that simple at this point.
May I say something?
Sure.
The terms that are used here are confusing. There are different types of space defined in the house. You can have living space, you can have usable space, but not all of them mean the same thing.
Yeah, the only thing I'm appealing is the certificate of occupancy. All I'm asking is to say the certificate of occupancy says it's a gazebo. All I'm asking is that the restrictions be removed. I thought he was asking me a question. I'm sorry.
But that's not the definition is used in the Boca Code.
Well,
It's
that's what's on the permit.
It's a living space or not. It's nothing to do with gazebo.
Yeah, but it says on the permit gazebo.
That may be
Permit
true.
say gazebo.
And
All I'm
maybe
asking is for it to say gazebo.
George, did you get your answer? You got your answer?
yeah, I got my answer. It's
Okay. So, you want to move to close our discussion?
I just have one more question.
I got one more question.
Yeah, that note on there has nothing to do with what we're supposed to decide, right? It's just a note, it's not illegal. The little note about the, was written on the permit.
No, your job is to either or agree with Mr. Wizinsky and then talk about the terms.
Okay, so
I'm trying to keep it as simple as possible.
Yeah, I know that. I was trying to get it down to the
Yeah.
final question, what we're really.
So I guess it depends on what decision that you make. If you decide that there's no merit for this appeal, then the case is done. You need to put that in writing. If you agree that there's merit for the appeal, then we'd have to discuss about the terms of that.
so,
And if I may, Mr. Chairman,
our discussion is over.
Mr. Wizinsky.
Oh, okay.
just very quickly, and whatever decision you make, I would just ask that the person who makes the motion articulate reasons for the decision, one way or the other. What is it that's driving your decision that the bill does or does not have? Based on the
And by point of order, all four of you, including the chairman, can make a motion.
I still had a question, Chad. In the request, is the request for a gazebo or for a dwelling place?
Well, I don't want to speak on Mr. Wizinsky, but really, the permit was issued a certain way by Mr. Hunter, and the question is, do you validate that decision, or do you agree with Mr. Wizinsky and should it be modified?
Yes, can you hear me? The gazebo is on the 1992 permit and on the 2018 permit. And all I'm asking is the certificate of occupancy matches the permit. That's a requirement under 110, the code book that you're following, R110.2. You cannot change the use on a certificate of occupancy that is different than on the permits. And on 110.3, you cannot put restrictions on the certificate of occupancy that are not on the permits. There are no restrictions on the gazebo on how it's to be used. There are no restrictions on the 2018 repair permit on how it's going to be used. Now, if they put on the 2018, that's what I'm saying is that's what you're deciding.
Okay, I still have,
Yes.
Rich. My understanding about the original permit for the gazebo was a structure that was open, that was 1 story above ground, and now the structure is 2 stories and has a roof. And I do not believe that what I saw was a gazebo as defined by the original permit.
That's what I was referring to earlier about it has changed. It's not the same structure.
Yes, and the change because of the trees on it. And the plans that were submitted in 2018 were approved.
Point of order, this is board discussion only, unless you're recognized by the chairman.
Well, back to what I was saying, the structure's not the same. Can't list it the same on a permit note. And he's asking, here's his appeal, to change the wording on the permit. It's different, can't change, I think.
Yes. Well, I could move at this point that the application for occupancy based on being a gazebo would be denied because it does not relate to the original permit of the gazebo that was structured for the 299.
I agree. Okay, should we move on to?
Oh, there has to be a second. Was that a motion, Mr. Wayne?
I'll second.
Can we move on now to our
You
decision?
can call for the motion.
You have to vote.
We did, really?
No, there was a motion made, there was a second. You have to have discussion and then vote.
Okay, so make a
Well, sure,
motion.
not like it was in 92, that's for sure. Sure, not the same thing it was in 92. This is a
Right,
totally different
okay.
thing.
Yeah.
I mean, I'd agree with 92, but this is totally different.
So
Different building.
I make a motion, you're gonna second it? Sounds okay, then I make a motion now to move on to our decision.
No, you don't, there's a motion on the table to deny, let me paraphrase here and help me out. I believe you made a motion to deny the appeal, correct?
Yeah.
Yeah, and it was seconded. So therefore you have to vote. I suggest you do a roll call
Oh,
vote.
because we are voting on it.
Yes.
Okay, yeah, I vote to deny.
Well,
the appeal.
let's do a roll call vote, which means the secretary will read off your name and you
Okay.
vote.
Okay, so Mr. Walter made the original motion?
Yes.
Okay. So Mr. Walter,
My vote is to deny,
well,
No, it's just yes or no.
Yes or no?
oh, yes.
In fact, I'm just gonna read the motion real quick. The motion that the application for occupancy based on it being a gazebo be denied because it does not relate to the original permit of the gazebo. And that was seconded by Mr. Cook. So roll call is Mr. Walter, aye. Mr. Cook,
Aye.
Mr. Palachi,
Aye.
and Mr. Peplinsky.
Aye.
4-0.
That means the motion passes, which means you move on to your next topic. There is no old business.
Do we have any old business? There is no. Move on to public comment?
Ms. Evans, could you read that phone number once again?
I would also like to note that I asked Amber Weber to check for emails as stated as part of the ways to comment publicly. And at 10:15 this morning, there were no emails on this for public comment. The number to call in, however, if you're watching on YouTube, is 231-256-8109.
Give me 2 minutes.
Okay, I make a motion to adjourn this meeting.
Let's just do a few minutes because
Oh,
there's a
okay.
delay.
Because there is a bit of a delay. I would further note that according to our YouTube channel, there are 14 people watching.
Okay, Mr. Chairman, I have not received any phone calls, so you can
I
proceed.
make a motion to adjourn this meeting. Anybody second it?
I just want to make one more comment. I will be appealing this. I can be,
Excuse me, you do not have the floor, Mr. Chairman. Please proceed.
Is there a second? John? This meeting's adjourned.
Okay, thank you, everyone. Ron? Ron? Turn off.